welcome to ACR Design Build's annual ADA lawsuit review that we perform every quarter. We want to keep our clients briefed on the upcoming factors that are hitting these properties that are considered Title III public accommodations, and some of the newest style of lawsuits that we are seeing in today's world. So before we jump in, just a couple introductions if I may. My name is Anthony Gashard. I'm the president of ACR Design Build. We've been around for about 38 years successfully. I personally hold multiple contractor's license ranging from a general engineering license, A license, B license, multiple C license, which are specialty license. In addition to that, I'm a graduate of Balin Institution for Architectural Design, where I've been designing ADA compliance for a number of years, also successfully. Our company also self-performs all of the corrections, both exterior and interior, for ADA compliance. We do not subcontract anything out, which allows us to bring costs down and also move through these lawsuits very swiftly. In addition to that, part of our team is Jason, who is our CASP inspector. Jason is one of the best at CASP inspections. In addition to that, he is also a DSA, which is the Division of the State Architect inspector as well. So Jason is performing inspections 8 hours a day, whereas most CASP inspectors are only performing one task. So that keeps Jason very current, and we work well together. Jason is not a ACR employee. He is part of our team. The reason I do not perform CASP inspections and I have a third party do it is we need to operate without conflict. In other words, we need to have a third party reviewing our work so that there are no conflicts. However, we come together as a team to resolve these matters. In addition to that, Tina is our ADA legal counsel. We refer all of our clients to Tina in the event they get caught up in these lawsuits, or if they need any assistance as they're navigating through or trying to be proactive. Tina is not on ACR's payroll. She has her own practice, again, so there is no conflict. And I'll get into why it's critical to have a team and having the best that you can possibly have to navigate through these things swiftly. So today's agenda, we're going to be talking about ADA and California Building Code definitions. Also dispelling some of the ADA myths, such as grandfathering, landlord responsibility, construction standards and how they're changing, 4 simple steps to ADA compliance, how to be proactive, the team approach again, proactive CASP report, meaning a CASP report to identify the corrections ASAP, ADA design, formal plans, city permit, ADA corrections, CASP reinspection, again, very critical. Just so you can kind of familiarize yourself where we're at in California with regards to the lawsuits. So as you can see here at the bottom, these are the leading states in the nation. You have California, New York, Florida, Texas, Nevada, Georgia, Pennsylvania, Illinois, Tennessee, and Washington. As you can see from this chart, California is well in the lead, and they are leaving the competition in the dust, so to speak. So this just lets you know these are the latest from the federal government that takes us through the last half of 2021. Again, here's another chart. This will kind of give you another view. This time, instead of states, we have the years in California here along the bottom. As you can see, last year, 2021, halfway through the year, we were at 6,300. So if you were to imagine the rest of the year, you'd probably finish about 13,000. What this is not showing are the lawsuits that are filed in not federal, but California Superior Court. So you can add another 20% for those types of lawsuits that are not depicted here. And that'll take you to about 15,000 or so. So I have put together this cheat sheet, and this cheat sheet, if anyone likes, you can email me or give me a call and I will send this to you. This is something to navigate through if you're planning on bringing the property into compliance, or if you've been caught up in a lawsuit, so you don't miss any of these tasks. So you can see we start here at the top, number one, and we finish at the bottom here with full compliance. So if your ADA lawsuit is filed, the most important thing at this time, again, I emphasize the word team, because we all work together to bring this matter to a close, and so it doesn't repeat itself. And that's the concern with a lot of these properties are multiple lawsuits. So you hire a quality ADA team, such as ACR. From there, the next task, which is the yellow, which takes the longest, you want to really get started on this as quickly as possible through your ADA designer, which is part of your team, who's going to create the formal plans and is going to ultimately obtain that permit. Now that permit it's required in California. A lot of contractors will tell you it is not. But any work that is performed within the accessible route on a property or a shopping center, a city permit is required. Most contractors are of the belief that, well, the concrete and asphalt are maintenance. That's not true, because anything within that accessible route, the city wants to have their eyes on it and make sure that it is being completed as correctly as possible in their eyes. We do not solely rely on the city for approving the plans, and we don't rely on them 100% for the permit. That's why we always have a CASP reinspection, which is a second set of eyes that are more detailed, more specific to review the work after the city inspector. So after the plans are submitted, and simultaneously you're reaching out to your ADA attorney, quality CASP report, and at the same time, the contractor is getting involved in reviewing the plans for all the corrections and providing the proposal to the owner. Your next task is to create the plans, submit, permit, perform the corrections, and then that brings us down to item 5, which is the final city approval permit. After that, we are still not done. We have a CASP reinspection, which ACR provides at no additional cost, because this is a critical component. A lot of owners obtain a CASP report. The mistake that they make is they use that CASP report as a design, and they'll hand it to an asphalt or a concrete contractor, and he will simply make those corrections. For instance, the CASP report will show that the ADA parking stall may have striping that is off a few inches, or a sign is not in the right place, but it does not tell you that that stall is not dispersed correctly throughout the center. So the contractor missed the design, completed the correction, and you're sued again. So the CASP reinspection and the design are very critical in bringing the property into compliance. So if anyone would like this little cheat sheet, feel free to email me or give me a call, and I'll send it over to you, and feel free to ask me any questions on, if you're having difficulty navigating through it. So, dispelling the myths according to the division of the state architect. So what we've done today is we've brought up 3 of the most popular myths that property owners, property management companies are being led to believe. So we wanted to add some clarification on them today. So the first myth: my business doesn't need to be compliant because the building is old, therefore grandfathered in. Well, the fact There are no grandfathering provisions. Grandfathering is the notion that ADA requirements do not apply to buildings constructed prior to the establishment of the ADA, which was 1990 and was started to be enforced in 1991. This, however, is not true. Regardless of the age or historical importance of a building, if it is open to the public, you must provide access to the goods and services you offer. So we always bring our clients back into the intent of the law. And if you truly understand what the intent of the law is, which is to bring all of these Title III public accommodation properties into compliance, then it makes the navigation process much easier. Now, these properties consist of strip centers, shopping centers, which usually have tenants, possibly a gas station, donut shop, dry cleaners, things of that nature, restaurants. So those are some of the types of properties that are required to be brought into ADA compliance. So if you have any questions, you can always send me an email and we'll get back to you with what our thoughts are on that particular property. So with regards to this myth, according to the ADA, the property must be brought into compliance. Second myth, the building is owned by someone else, so I'm not liable for violations. Fact, compliance is not only the landlord's responsibility. Both the lessor and the lessee are responsible and liable for accessibility of a facility's public areas. If you lease or rent a facility, it is advisable to have an agreement with your landlord about who is responsible for providing and maintaining the facility's accessible features. Lease and rental agreements must stipulate whether the property was inspected by a CASP and if the property is compliant. So here, the state of California is trying to push the property owners into an area in their rental agreements and their leases in stating who has responsibility and liability. Most of the leases are constructed that the tenant has the responsibility of compliance for the interior, and the owner has the exterior. However, some of the most popular allegations in these lawsuits are addressing the front entry door. So who has the front entry door? Is that the tenant or is that the owner? The reason we bring this up is that in order to bring this front entry door into compliance, it can or oftentimes is quite expensive to bring a glass commercial storefront door into compliance. Once the exterior is brought into compliance, these plaintiffs and their law firms are starting to go inside and file lawsuits. So they do not seem to be ending simply because the exterior has been brought into compliance. They're just bringing up more detailed items or allegations to name in the lawsuit. So with regards to a front entry door, to bring that in compliance can range anywhere from $1,500 to $5,000. The CASP inspectors oftentimes will state in their reports to simply make an adjustment. Well, that's not accurate because the pressure is 5 pounds of pressure to open the door. That mechanism is set at the factory. There isn't an adjustment for it in most cases. The adjustment oftentimes for the closing speed, which is 5 seconds, that is worn out. And again, there typically are not kick plates. So it can be a costly task to replace this door, but it becomes an argument. Who has the door? So you may want to look, if you have multiple entry doors within your center, to sit down with the tenant and say, hey, by the way, we need to add an addendum here that this entry door is part of the interior, so that when a lawsuit is filed, the intent of the courts is to not clog them up so that you have this identified in your leases. So that's the intent that the state of California has kind of levied on the owners and the property management companies, is to describe full detail of who has compliance, so they don't end up before a judge, because the judges are really fed up with these lawsuits. Myth: the standards are always changing, making it hard to stay in compliance. Fact: the ADA has only been updated once in 20 years, although the California Building Code is amended regularly. Your facility's compliance is determined by the building code in place when your facility was originally built or last altered. A once compliant facility is not made non-compliant because the accessibility regulations and guidelines are updated. However, accessible features must be maintained. So this is a large gray area, because you have ADA compliance and you have California Building Code, which in most cases is more strict. So you will find CASP inspectors and attorneys doing their best to protect their clients, but oftentimes they're not looking at the long-term picture. Example, you've been caught up in a lawsuit, you've had a CASP inspection done, your CASP inspector provides you with information stating, hey, you do not have to make these upgrades because your property was compliant in 1960, well before ADA compliance in 1990. But they're leaving out the key words: last altered. So if you had a property built in 1960 and your defense is, we're not going to put in curb ramps or detectable warning domes because the property was compliant in 1960, the attorneys will come back and challenge you. It may cost you $20,000 to $30,000 just in legal fees to defend that position, because the plaintiff's attorney is going to come back and they're going to request through discovery, where is the paperwork that states that your property was compliant? Where's the threshold? Where's the permit stating this property is in compliance in 1960? Now, if you happen to be 1 out of 100 owners who have this documentation, the next step is, how do you guarantee that it was brought into compliance correctly? So most owners will not have this type of information, which is why it's critical to have a set of formal plans and a permit going forward. If you are correcting a shopping center in 2022, you submit your plans, you have a permit. Those plans and that permit are attached to the property. The CASP report isn't. The permit is, and it states you now have a threshold that this property was brought into compliance in 2022, and you have a CASP inspection and a re-inspection. So now you've created a paper trail to say, hey, the property was brought into compliance in 2022, and we are now compliant. And now you have a threshold or a benchmark to move forward. So when a CASP inspector or an attorney gives you advice to say that, no, you don't have to make these corrections because you haven't altered the property. Now, an alteration can be something as simple as pulling a permit for a roof, pulling a permit for a sign, having the property seal coated and restriped. All of these are last altered. That's why I highlighted this in red. That is a key component. So most of these properties, at the very least, have had asphalt repairs and seal coating over the last 30 or 40 years. So again, when your attorney and CASP inspector are trying to assist you in helping you not put the curb ramp in or not put the signs in, they may not be giving you the best advice because you can be set up for a second and third lawsuit. Here's another example that give you a different perspective. Let's say you were caught up or your attorney on your first lawsuit settled it for you for $10,000 and you didn't make these corrections because your defense is we do not have to make it because it was compliant in 1960. Keep in mind from a psychological standpoint, the plaintiff that is filing these lawsuits is not on the highest level of ethics and morality in today's world. They are driving by the property. They are looking for a curb ramp that is not there. They're looking for a path of travel from the city sidewalk that's not there. They do not know what your defense is. They do not know that the reason you haven't put these items in is because your attorney or your CASP inspector told you you didn't have to. So a lawsuit is filed, a second lawsuit. Now, once that second lawsuit has been filed, you are now caught up in the system again. You will probably spend an additional $10,000 to navigate out of it, and you may be forced at that particular time through the settlement to actually install these items. So what we do with our clients to bypass all of this is we take our clients down a path of stating, bring the property into complete ADA compliance and disabled access as quickly as possible and correctly, and create a paper trail. So be very careful when getting advice that you do not have to make these. Keep in mind that the ADA says you do, and that's where 99% of these lawsuits are filed. The next item is the second gray area. Most people that are involved in today's ADA world and making these corrections, if there was one item that we would love to change, it is the biggest gray area of all of them. It's called readily achievable. So readily achievable means easily accomplishable without much difficulty or expense. The application of the standard is highly case specific and depends on a number of factors that include the nature and the cost of the action, the facility's financial resources, and the financial resource of any parent, corporation, or entity, the administrative and fiscal relationship between the facility and any other parent, corporation, or entity. So again, when you're caught up in one of these lawsuits, your attorney or your CASP inspector may tell you that you do not need to make these corrections because it's not readily achievable. One of the most common defenses is that it's not readily achievable because we have a financial hardship, that we cannot afford it. If that is your defense, then be prepared, because the plaintiff's attorney, if they're aggressive, the first thing that they're going to do is request an appraisal on the property to see if there's any equity. If there's equity in the property and you haven't made these corrections to the property, your defense doesn't hold much water. In addition to that, they're talking about financial resources of any parent corporation, meaning if you own any other properties that have equity in them, you should be able to bring them up to par with ADA compliance. They may ask for rent rolls. They may ask for banking accounts, checking accounts, personal accounts, anything to show or unravel your defense that you have a financial hardship. So be very careful with that defense. Now, while you're providing all those documents through discovery, keep in mind that you're also running up your attorney fees for both sides. So keep that in mind when you're establishing a defense that we don't have the money to do it. Be very careful, because an aggressive firm, and there are a few out there, they will run you through the ringer on discovery and providing and defending your position. Readily achievable can also mean something that is a structural element. Let's say you have a sidewalk through your shopping center and you have decorative columns that are supporting a roof structure overhead. And you cannot get a 4-foot wide path of travel through. So you need to put a set of plans together, and it needs to be documented that it is not readily achievable and that it is technically infeasible to comply with the code. The reason you must have plans is because local authority, which would be the city that the property is within, their building official needs to sign off on the plans and agree that it is technically infeasible and not readily achievable. So an architect can't do that for you, a contractor can't. It needs to be approved and acknowledged by the building official at the local authority. So that's why, again, that a set of plans and a permit are critical, especially if you have something that you cannot comply with. So usually right about here, we would break for a couple of questions, and I see that there are a couple of questions. Here's a question. Thank you for sharing all the great ADA information. Can you please take a moment to explain why a CAS report is needed as the first part of your steps? Sure. The reason a CAS report is critical, and there's a variety of reasons. You need to document what the corrections are. So there's a paper trail that we take you down that brings the property into compliance in the best manner. The CAS report is performed by a CASP inspector set in place by the Division of the State Architect to truly tell the owner what is wrong with the property. You don't want to listen to or pay attention to the actual lawsuit or complaint with regards to the allegations, and I'll tell you why. Most lawsuits only identify 2 or 3 items that are necessary for settlement. For instance, the most common years ago was the property does not have a van accessible parking stall. And it may say the sign is incorrect and the striping is faded. If you follow your legal counsel's advice and you only bring those 3 items into compliance and you ignore the remaining in the CAS report, which may be 15 additional corrections, you are leaving the door open for that second and third lawsuit that is noted within the CAS report. So one, the lawsuit hopes you only pay attention to 3 of the allegations and only fix the 3. Again, when you're caught up in these lawsuits, you're going to be flooded with multiple attorneys that are offering $1,000 or $1,500 lump sum fees to settle your case. Be very, very careful with that process. If an attorney is offering $1,000 or $1,500, they are going to spend a limited amount of time. They want you to only focus on the 3 allegations and settle that case as quickly as possible and move on. We disagree with that approach. We look at the CAS report. The CAS report tells us the corrections. We design around the corrections with regards to ADA federal and California guidelines. So we take everything into consideration. We then have local authority approve it. So the CASP initial inspection is critical in helping settle the lawsuit, because the attorney, your attorney, defense counsel, hopefully you're using TINA with ACR. What we do is once we have the lawsuit in front of us, we review the lawsuit, we instantly order the CAS report. I compare the lawsuit with the CAS report. We send it off to your attorney, and we tell your attorney that 2 of the allegations in the lawsuit are not correct. Here's the CAS report that proves it. So now your attorney can go back to the plaintiff, and when they're asking for $4,000 for each incident, your attorney can come back and say, no, here's the CAS report. 2 of your allegations are incorrect. So we're whittling down the ask for the settlement. So the CAS report is critical for that reason, and also for identifying the corrections so we can prepare the design. So I hope that answers your question. And if you need a follow-up on it, feel free to email me, and I'll help you out as much as I can on that. So how to achieve ADA compliance? Step one, make sure you hire a quality team. And notice how I emphasize team. That consists of ADA designer, contractor, CASP inspector, and an expert attorney. These are critical because they all work together. Again, once we order the CASP inspection, we compare it to the allegations in the lawsuit. We send it off to the attorney. The attorney is working on the settlement by beating them down on their ask because of the actual corrections versus allegations. So all of us have to work together. And what we do is we create a thread between legal counsel, the owner, property management company, myself, the CASP inspector. So we're all navigating on a daily basis to make sure that we bring this action or this matter to a swift close in the most economical fashion. So having a good team is in our opinion, imperative. These three entities should be separate, but come together and work as a team to resolve your ADA issues. This eliminates any conflict. The reason I bring that up is we are seeing more and more CASP inspectors that are also part of an asphalt company or a concrete contractor on their payroll, so to speak. There are reimbursements, there are sales fees that are being paid, commissions. And we're running into more and more of these properties that are not compliant, although they're being signed off as compliant. So be very careful that your team is not part of one entity such as ACR. Our CASP inspector is a third party, our legal counsel is a third party. So there is no conflict. So ask those questions. ACR can provide the design, formal plans, city permit, and perform the corrections, and provide the CASP report and refer the ADA attorney. So we can handle all of that for you. ACR doesn't get a fee or any type of a kickback fee from our CASP inspector, nor do we get one from our attorney or vice versa. We are separate third-party entities to make sure there is no conflict. Make sure you obtain a city permit. This adds another level of protection with the property. California requires a permit to work within the accessible route. The accessible route is a key term. Most contractors, architects, designers, and attorneys are not familiar with this term in its entirety. The law does not require simply an ADA parking stall or a sign or a curb ramp. It needs to have a complete accessible route, meaning a path of travel free of barriers from the city sidewalk. Only 35% of disabled persons navigate by public transportation. So they do not have a car. They are making their way by public transportation in the city sidewalk. So there has to be an accessible route within reason with the signage, directional signage, all the things that are required in California Building Code and ADA. So the path of travel from the city sidewalk, a path of travel from the ADA or disabled parking, curb ramps to all of the front entry doors. Now, if you happen to have a shopping center that has two buildings, you also have to connect those buildings with a path of travel without any barriers. Most are not aware of this. So if a disabled person pulls into the liquor store, goes in, buys goods and services, then all of a sudden looks across the parking lot to the Del Taco, and they have no way to get there. And they are on the same parcel. You need to connect them internally. You cannot force them to go back out on the sidewalk and navigate. They need to be connected internally. So the other reason a city permit is necessary is, one, it's required. Two, it creates that threshold for you that you can attach with the property. So designing and having a city permit is imperative, in our opinion, to provide a documentation trail on when the property was brought into compliance. Step 2, be proactive. Obtain a quality CASP inspection and report from ACR. Being proactive means get the CASP report as quickly as possible to define what the corrections are on the property and start working through bringing the property into compliance before a lawsuit is filed. That would be, if you haven't performed a CASP report on your property, I would highly suggest you do so. Now, you will find CASP reports that are all over the place with cost. I've seen CASP reports as low as $75. They're 2.5 pages long. Our typical CASP report is around 45 pages. Some of them go up to 100 pages. But a good quality CASP report from ACR that deals with and establishes corrections for both federal and California will range anywhere between $450 to $750. A typical 3 to 5 property with 3 to 5 tenants would run, for the exterior, would run probably $550. So that kind of gives you a baseline for what a good quality CASP report should go for. ACR can provide these reports. However, if you consider another company, ask if they also work for the law firms that are filing these lawsuits. Now, there are a couple CASP inspectors, actually I shouldn't say a couple, there are a few CASP inspectors that are now working for the law firms who file these lawsuits. So be very careful and ask the question. You do not want a CASP inspector that is on both sides of the coin, so to speak. If the CASP inspector is working for the attorney that filed this lawsuit, you wouldn't know that. In turn, if you accidentally or coincidentally contacted them, they already know what your exposure is. That's a major conflict that owners are not being told. So if you decide not to work with ACR, feel free, or make sure that you ask the question, say, hey, by the way, do you work for the law firms that are filing these lawsuits? And get something in writing, because in our opinion, that's an unethical practice. So be careful. Make sure the CASP inspector is not involved financially with a construction company that performs the corrections, such as asphalt or concrete companies. Again, conflict. We are seeing more and more of these properties that are being signed off as compliant, and they are not. I recently found a property in San Diego, an apartment complex. The contractor performed the work. Their CASP inspector was part of the company. He signed it off, and the slope on the property was 10%. 8.33 is the maximum, but yet they signed it off. So I brought that to the owner's attention, and now they are in a debate with that particular company. But our intent is to bring to the attention to our client about non-compliance. Unfortunately, we may be the bad guy from time to time. However, we are protecting our clients, and that's our intent. Step 3, make sure you're working with an expert ADA attorney. ACR can refer you to our expert at a discounted rate for our clients. It's critical that your attorney work together with a designer and CASP inspector to confirm the property is in full compliance. Now, it is important that you have an experienced ADA attorney for a variety of reasons. You may very well have a brilliant legal counsel for years that may be a real estate attorney or general counsel. However, when it comes to ADA compliance and knowing who your opponent is, which there's probably 7 aggressive law firms that are filing these lawsuits currently. And if you work against them every day, you know exactly what their angle is. You know exactly how they're going to proceed. You know if they're going to come back after the work is done and inspect it themselves and open up a second lawsuit. So it's important to know how to navigate through the federal court system, which is different than California, Superior Court. So having an ADA and legal counsel on your side is very important. Step 4, CASP reinspection after ADA designer contractor has or have performed the corrections. Most owners do not obtain the reinspection because they assume their contractor performed the work correctly. This is a mistake. This task is critical for compliance. Again, the CASP reinspection after the city inspector has reviewed it for the permit is critical. You now have an expert set of eyes that is going over the project again that will provide you with a complete report that the property has now been brought into compliance according to federal and California law. A lot of times the owner will be caught up in a lawsuit, obtain the CASP report, not get a set of plans, not get a permit, simply hire a contractor. They do not know 100% if that property has been brought into compliance. And I must tell you, I find 80 to 90% of the properties that the owner believes have been brought into compliance are not. So we offer this reinspection at no additional cost because we believe it is a key component to bringing absolution to ADA compliance so that the owner or the property management company can rest freely. So making sure that CASP reinspection after the city permit is performed. And if it's performed and there are still corrections, then that's on the contractor and the designer. They need to bring this property into compliance. And that's what we provide. We raised our hand to make sure that all of our work is double and triple inspected. ADA and disabled access summary. Just so a quick summary, what ACR provides for full compliance and protection. Deliver a high-level CASP inspection, which is right off the bat important, and report to truly identify all of the corrections. Again, we want to compare that initial report with the allegations and make sure that we're making the corrections according to the CASP report and not the lawsuit. If we make them according to the CASP report, we know we're covering and taking care of all the corrections, especially if we end up with a CASP reinspection that says all has been covered. We specialize in providing city permits, which require a formal design and city submittal process. Again, having a quality designer. Oftentimes, architects and civil engineers do not have all of the knowledge with ADA compliance. So when we perform our ADA design, I run it through 2 separate CASP inspectors before we send it off to the city. Again, there are times that we're seeing in designs that the layout for the ADA parking is not dispersed correctly. Most often the architect, for cost reasons, will lump all of the ADA parking together. You need to disperse them throughout the shopping center. In other words, You cannot make a disabled person park in front of the liquor store and make them navigate 500 feet to the video store or the music store. You need to disperse them accordingly throughout the center. So most architects aren't aware of that. So keep that in mind with your design. Refer our clients to an expert ADA attorney at a reduced rate, which is what we provide with our team approach. We perform the corrections and work with the city inspector and CASP inspector to confirm work has been performed correctly. Always deliver an approved set of design plans, city permit, approval, approved final city permit, and a CASP reinspection report. In fact, today I brought a sample of what we actually provide, and this is what it actually looks like when we're done with the project. So we have our initial CASP inspection here. So that tells us what all the corrections are. And as we perform this, you can see on the back, we have a city set of plans with a formal design that are folded up nice and neatly inside this package. On the top here, you'll see the top of our permit that has been signed off by the city inspector that states all the work has been performed correctly according to these plans. Then we provide behind this document a second set, which is a CASP reinspection. So you've got a complete set of documents here that should be placed in a secure location that will be attached to the property. So now you can go back and review everything at any time in a nice, neat package. I believe we're the only company in Southern California that's providing this exact service. So I hope this has been informative for you today. Here you have my email, you have our phone number if you want to jot down any questions. If you want or you have concerns about a specific property, you can send me an email. I will perform a site visit that doesn't cost anything to the owner of the property management company. And I will give you an evaluation on what you should do or how you should navigate to bring this property into compliance. So just send me an email with a property address and I will be more than happy to swing by and I'll get back with you with what we would do or how you should proceed on that. I see we have a question here. Can you show the step 1 again? After all the steps in this topic, please. Can't see your set of documents. Is there another camera? This is from Judy. Are you referring to the I assume you're referring to the CASP report. So what I will do is that is step 1. I will open this package for you here quickly. And I will bring out the CASP reinspection for this property and give you a sample of what the project looks like. Here's a sample of inside the project, what you can see. Now, this is a walkway that is also a ramp with ADA railing. And you can see that it has been brought into compliance. Underneath it is the level showing the percentages. So there are multiple documents within this report that bring the property into compliance and is documented. So I hope that answers your question. You can feel free to call me or send me an email. But again, I hope this has been very informative for you today and not too lengthy. And if you have any questions, feel free to send me an email. But keep in touch with us to find out when our next webinar will be coming up. Our next topic is going to be how to navigate the complete accessible route. But today was all about adding definition and defining how you should proceed in the event of a lawsuit and how to be proactive. Thank you much for joining us, and I appreciate it. Have a good day.